Well, hello, everyone. If you are watching this, you are a person who has a CRPM credential. And so we are today talking about the top legal issues in property management as of February 2024. Hot breaking news, if you're watching the news today, which is February 28th, 2024, the Arizona Attorney General just filed a lawsuit against a whole slew of apartment communities for using a product called RealPage. RealPage is kind of like Zillow. It helps management companies figure out what the market would be. And so it's her argument is, and it's about an 80-page lawsuit, that they are colluding with each other by setting prices and fixing prices. We've been watching this happen around the country in quite a few states. No one's really immune, but the idea is if you're talking about pricing, or if you're using a tool for pricing, like RealPage or whatever other software, you are artificially modifying or causing harm to the market and causing harm to the renters and colluding criminally. I don't agree with that, but I can tell you this is a big issue. It just happened today. And so we'll all be watching that. There are also some movements that she's made in some of the fair housing lane, and we're going to talk a little bit about that too. But so buckle up your seatbelts. We're on for a quick update of what I see as some issues. Once again, this is my information. Many of you always say, well, where's Dr. Victor? We're still there. It's just politically not correct. And so if you put it in, it still gets you the same website. The legislature is still in session. So whenever we do this update, I want to remind everybody, if they are still in session, we are still at risk. So right now they are in the session where they can do what's called a striker bill. They remove contents of a bill and replace it with something. We are watching that. There's nothing out there that is making me too alarmed. They're talking about this particular new statute regarding dogs, that landlords would have to allow all dogs, no breed restrictions or size restrictions. They're fighting over that language. Maybe just be breed restrictions, but not size restrictions. I can tell you, I am not terribly concerned. And here's kind of the reason why. If they make that the law, it will actually relieve a little bit of pressure on landlords, because a lot of tenants claim to have an assistive animal because they don't want to pay pet rent, or because it's a pet restricted breed. And so you might reduce some of that. Additionally, if the animal becomes aggressive and you were forced to take that particular breed by the government, it may reduce your potential liability if you had no information and no way to know that that dog was aggressive. There are things also called rule petitions. These are suggested changes to rules that are like rules of procedure, rules of evidence, that are asking our Supreme Court, our Arizona State Supreme Court, to modify. There are a couple of those out there. If that is important to you, you should look at them. There's probably about 40 that are pending. So here's where we are. We once again had a whole slew of legislation that didn't get out of committee. They were some really bad ones for landlords. Rent control by far being the most egregious. If you don't understand why rent control is bad, go look at New York, San Francisco, cities that have had rent control for a while. The rents are outrageous and no one can really afford to live there. And so there's all these artificial measures to adjust that. They also tried to restrict your ability to non-renew a lease and the amount of deposits that you could charge. If you hear of any of this, all of these got killed in committee. They didn't get out even for a vote. And so your tenants sometimes will cite a state bill or a House bill, and just know that none of those came out. But if you have an issue, you can always go to the state legislature and look it up, or check with your attorney. Today, we're going to talk about really the issues that I see that are potential issues that are still out there. And really everything that I talk about is how do we reduce our risks in property management. And here's what I want to tell you about. These are the top concerns that I saw in 2023, and by far fair housing is still out there. We have a new attorney general, and we're not really sure what her interpretation of some items are going to be. So we're watching that. Remember that the interpretation can change when there's a change of leadership. So right now our concerns are these, that there are more fair housing cases. They continue to go up every year. The application terms and process, I've been worried about for a while, because we see statements coming out of the Attorney General's office, but also from other government officials, that landlords are cheating tenants, that they're using deceptive practices on an application, that like a bait and switch idea where they want to rent the house, they fill out the application, they send the holding deposit, they get to the house and it's terrible, or the terms of your lease or something they won't agree to, like no smoking terms, and they're a smoker. So we're calling for transparency in those terms. Sample leases are available on your website, sample application criteria available on your website. These are just some important things for you to know. And we also hear that the terms themselves, they have some concerns that there's what we call junk fees, where you're not disclosing all the different fees that are associated with renting the property and what the rules and terms are. If I knew I couldn't park my boat at the property, I would have never applied, but I was already too far into it when I finally saw the lease or the CC&Rs, and now I'm stuck. And so it's kind of that idea. And the reason why it's a fair housing issue is because they believe that it's discriminatory in the pattern or practice. So it disproportionately impacts one particular group more than another. And so we like to pay close attention to that so we can see, is it a risk? And then what do we need to do to adjust that? So let's start with applications. I tell everybody to use a consistent company to help screen your applications, know what you're looking at, but also letting the tenants know ahead of time what the rental criteria is. And the thought behind that is, if you're telling them before they submit the application and pay the fee, maybe they won't apply if you don't rent to registered sex offenders. And I understand the idea is there's only a certain amount of money that they have available. If they are putting in 2 or 3 applications where they wouldn't have even applied had they known you wouldn't have accepted them. The idea is that you're intentionally keeping that money. You're not really running the application. It's just an extra source of income for you. So be careful about that. I encourage everyone to disclose their rental criteria on the website or minimally handed to them at the time they're filling out an application. Just remember that if you have bad rental criteria, that now is clear proof that you have a fair housing violation or some other kind of violation. So what is good rental criteria? Think about what you're asking. What are better questions? So what's your name, or all the names you've ever used? A pattern that I see frequently is they will leave out a middle initial, or they'll use a different middle initial. And if you had used that middle initial, they've got a long criminal history or a long eviction history. Or they'll change the middle name with the last name, or they'll go by a maiden name. And so ask them, what are all the names that you've ever used? Because that's going to give you a better search result. We see all the time, have you ever been evicted? And I'm like, no, I haven't been evicted yet. Hurry, court's in 3 days. That's why I need to move in. Better question is, have you ever received a breach notice from the landlord? And if so, what's the status of that? I talk about this all the time. I do not like the question, do you have any pets? I like the question, do you have any animals? And if you do, are any of these animal assistance animals? I know that the Attorney General's office was not crazy with that question because they feel like you're going to use it as a screening method to screen out disabled tenants. Please make sure that you have adequate evidence that that is not true, that you're just helping them process that quickly and have the right information so that you can approve those requests. Instead of asking, do you have any felonies? Ask if they have ever been involved in any criminal activity. Do they have any open arrests? Getting clear information about the case number and the county that it was in. Asking if they've ever filed bankruptcy. Have you received demand for payment or collection notices? Because that's going to give you a better idea about whether this person is financially solid. And then other things that I think are important. Do you intend on filing things? Well, they're going to say no. But if they move in and declare bankruptcy 3 weeks later, that looks like they materially falsified that on the application. And I also like the catch-all is, there's anything else you'd like me to review or think is relevant, send it in with your application. Material falsification is a way to terminate a lease or not give them possession, even if you've already previously approved the application. If they didn't lie to you, though, because you didn't ask the right question, you can't get them out. And so be very careful about what you're asking and the format of how you're asking that. And then one of the questions that I hear all the time is, well, do you look at their social media? There have been some bills suggested where a landlord is not allowed to go look. I think, why wouldn't you? Do you match their driver's license with their application? Because if they say they've lived there for 2 years, why doesn't the address on their driver's license match that? That's kind of a red flag. Have you spoken to the last landlord? More and more often, I see that people are not even calling or checking with the previous landlord. And you should, but you should also check the last 2 landlords, because maybe the first one wants to get rid of them and the second one's actually going to tell you the truth. The trends that I have seen, not just here in Arizona, but nationally, is that some cities and states actually are removing or blocking information. There are a series of counties, cities, and states that are blocking any credit issue that came up during COVID. And you don't even have the right to know if that person got rental assistance or paid those bills on time. And they're just blocking those public records. So you really need to think about, what are you using to verify who they are and what their history is? Because that's going to create a risk for your owner. And if you get it wrong because your magic crystal ball wasn't working that day, your owner may actually come in and try to sue you. So what's the risk reduction? Hiring a third-party screener is a good idea. They know what they're looking at. They know at a driver's license, when you can look at it and know that that's a registered sex offender because of certain type of the style of that particular driver's license and some dates on it. Do you know that when you're looking at a criminal report, sometimes that class 3 felony is higher than a class 6 felony? It depends on the state. The level of the classes are not always in the same order, and you may not understand that. So using a third-party screener that's never met them, that doesn't know their ethnicity, their religion, doesn't really know anything about them, but whatever's on the paper, that really is the safest way to avoid some risk. Part of this discussion too is, what do you check first? We used to probably check criminal because it was the easiest. There is some guidance now from HUD that said, be careful if you're using that first, because you're screening out some qualified tenants, and you can't ban all felonies forever. That's called the ban the box issue. But think about the rental history probably is the most important factor for you about whether or not they're going to be a good tenant, because they may have credit issues, but they always pay their rent. And then what order do you check it, and then who checks that order? I want you to be very careful about creating new terms for your lease. Frequently, you'll go to a class and you'll learn that there's this new clause, and be careful. We've seen them kind of pop up in batches. And I really get worried about that, because I wonder who's teaching you that, and then do they understand the implications? So if you are doing property management, you need to get the newest copy of the Landlord Tenant Act. It came out in 2023. So throw the 2018 copy away. It's not valid anymore. It's had lots of changes. But think about what the terms and conditions are that you've listed in your lease. If you're using AAR, you are sound. But if you're adding additional clauses, vet those through your attorney. Because you can accidentally include a clause that violates the law, which is violation of 33-13-15, by taking away a right or limiting a right or a remedy under the Landlord Tenant Act. But more than that, you might be actually creating a discriminatory practice. And this is the one I like to use. You use a black buy fee, and you charge that if there was an animal or children that live there. So an animal may be an assistive animal, and therefore it's not a pet. And maybe you can't charge that fee because it's more like a wheelchair. And why are you only charging it if tenants live there? Adults have accidents too, and may damage the carpet. So think carefully about a black light fee and when do you charge it. I just started seeing that. And don't add any clause or a phrase to your lease without talking to your attorney. One of the ones that I have seen that kind of was popping up last summer was a clause that said you agree you will not say anything bad about me on a negative review online. And there's a federal law called the Consumer Review Fairness Act that makes it illegal for you to include that clause in your lease. And you wouldn't know that, but I think someone must have encouraged you to add that, because we saw literally hundreds of leases that started having that. So do not include that clause. Our newest issue was just, we have to talk about that. It's here to stay, at least in 3 cities. So in Phoenix, in Tempe, and in Tucson. Source of income is a new protected class. If you have not gone to a fair housing class in the last year, and some of you don't have to because you only have to take it once every 3 years, you need to go in now and need to learn about this. If you have any properties in the city of Phoenix, Tucson, or Tempe, go to their website and learn all about this, because they have some unique policies and rules for each of those cities. So basically what this says is that they're going to take all legitimate, reoccurring legal sources of income and treat them fairly and equally. What that really means to us is that you're going to be required to take Section 8 vouchers or other forms of vouchers, or take rental assistance from the tenant for their move-in monies. We're not talking about rental assistance in general, but for their deposits or their move-in funds. Like once again, it's the city of Tucson, Phoenix, and Tempe. They've created this additional category of protected persons, just like a disability or race or religion. And it basically just says you're required to accept that voucher. It doesn't make you change any of your background requirements or charge any less rent, but it is a big deal. So here's what it looks like if you've never seen it. It basically takes the relationship between the landlord and the tenant, which is a straight line, and they add a line underneath it. So it's kind of like a triangle. And so the housing authority, the city of Phoenix, the city of Tempe, or the city of Tucson, they have a housing authority. In Phoenix, it's called Quadel, which is the one that authorizes and operates that program. And they make the tenant fill out certain paperwork and see if they qualify to be in that program. The landlord has a lease and an application to see if the tenant qualifies. And then they fill out a contract, but the tenant has to sign a contract, but the landlord has to sign a contract with the housing authority. The landlord has to sign a contract between them and the housing authority. And so it's really like a triangle, and there's lots of parts to this. And you want to make sure that you understand that before you sign that. So what does it mean for you? Make sure that all of your staff now responds, we participate in the housing choice voucher programs, and we fully comply with all of the source of income rules for Phoenix, Tempe, and Tucson. The one issue that is constantly a problem is that when the tenant applies, they may or may not tell you that they have a Section 8 voucher. They cannot sign a lease that will bind the city until an inspection is done, and that can take a few weeks. And that's a concern because you're pulling it off of the market and no one's getting paid for that. So it becomes a problem. You need to have a policy in place of how that's done. And they may require you to make some changes or improvements before they'll sign the lease. You are not required to sign a lease with them if they require you to do additional changes. Just like that, you are not required to charge a different amount of rent. You're not required to change your policies, but you do have to agree to comply with their program guidelines. So once again, go to their website. There's a whole training video on all of those websites. And they will make you take an auto deposit. They don't write you a check. It's automatically put into your account, and they can automatically take it back out, which is a problem for property managers because it's hard for you to track that. So you don't have to change your rental criteria about how long they've lived somewhere or their criminal history or any of those things. You process their application the same exact way. You just use that voucher as like a paycheck or some other source of income. And by the way, the housing choice voucher is not the only additional source of income. They have a lot of other categories like spousal maintenance and child support and food stamps and lots of other categories. So you want to check that out. I believe that the rental history is probably one of the most important factors that will be a good indicator of whether or not this tenant's going to be a good tenant for you. So you can't apply any additional requirements. You can't charge them any additional amount of money, but you can use the same criteria. Like, did you pay the last landlord everything that's owed? And one of the problems with a person who is subsidized is they don't really have any additional income to pay for those damages. And so sometimes they're having a problem coming up with a deposit, but they've left the last landlord owing them some money. So you can reject that, but only if you're rejecting all other tenants or all other applicants who also owe the previous landlord money for damages to the home, late pays, all the normal stuff that you would be looking for. Using the exact same criminal background check, we talked about that ban the box issue. You cannot charge them any additional fees. You can't use any stricter requirements, but you can use the identical ones. And Tucson has a unique interpretation of sufficient income. Like typically we say that a tenant has to have 2 times or 3 times the monthly rent as income. Tucson created this next slide as an example, and we think Tempe and Phoenix may start to follow this, and no one's challenged it, but here's basically the idea. If the rent is $2,000 a month, and the voucher is for $1,400 a month, then the tenant's portion would be $600 a month. By the way, all of that is on a particular form. You can't charge any more than what they agree, and you can't charge the tenant for any additional fees. Everything has to be included on this particular, the form that they have you sign. So if we were in Tucson, if the tenant's portion is 600 and you charge 3 times whatever their rent is, so normally a tenant would have to have $6,000 in rent, right? 2,000 times 3. Their belief is you can only charge the tenant to have 3 times whatever their portion is, not the entire rent. So if their portion is 600, they would only have to show income of 1,800. And if the subsidy is 1,400, there's a problem, right? What if they have 0 rent? Because there are some tenants who live in some properties where the 100% of their rent is paid. What about food? What about laundry detergent? What about clothing? What about transportation? What about all those other things? And so this is an area where we don't agree. There's not consistency. And so my opinion, and it hasn't been litigated yet, but my opinion is you have the right to demand that $6,000 proof of income. You just take that voucher and add it into the pot. Like I said, Tucson disagrees, and we expect this to be litigated. We just don't know what's going to be the final answer. You do not have to take a lesser amount. So you will find from time to time that the city will say, we won't do 2,000, we'll do 1,800. And that's an offer, just like any tenant making an offer. And you can say no. You can reject that applicant because they've not agreed to pay the amount of money that you're requesting. And you can deny it for that reason alone. Here's a very important part. It is illegal for you to have a side deal with the tenant. So if they say total rents are $2,200, you can't charge the tenant additionally for pet rent or anything else outside of that contract. The odd part is the city of Phoenix has now had some new interpretations of what they will cover, and they'll send you a letter saying, we will cover this in our main contract. You need an addendum that the tenant's going to pay for these other things like pet rent or carport rent or garage rent. I don't know how they get around the side deal language of the federal CFRs, the federal regulations, but this is their interpretation. And so I would require them to put that in writing, because I worry that these particular employees for the city are misunderstanding that particular part of federal law. But that's what they're doing right now. By the way, if you give the tenant any kind of breach notice, non-pay, a 10-day for having an unauthorized animal, whatever, you have to send a copy of that to that housing authority. But there's no special rules about what language has to be in that notice. We used to think that that was the rule because all of the tenant advocate groups fought us for decades. And in order to get the ordinance passed in Tucson, they finally agreed that that was wrong, and those particular rules didn't apply to housing choice vouchers. Very interesting, because currently, now that that's been in place for about a year, the free tenant advocate groups, excuse me, like CLS and Southern Legal Aid, they're starting to create new pleadings and say, well, because you take Section 8, which you're required to do in Tucson, that means you have to give your tenant a 30-day non-payment of rent notice. Because under federal law, under certain programs, there's a thing called VAWA, Violence Against Women's Act. And if Section 8 is covered by VAWA, then by taking Section 8, you have to use the federal rules. Under federal rules, the CARES Act may still apply. And therefore, everybody in Tucson has to give a 30-day non-pay. We're currently litigating that. I think that is absolutely not what our Arizona Supreme Court has required or even suggested. So I personally think that that is not, excuse me, not the law. I'm going to add a cough drop here since I'm getting a little bit of hoarse. Non-renewals is important to discuss because you cannot renew them without that housing authority signing that agreement. It's called a HAP agreement. You cannot increase the rent, and you cannot renew it without them signing that agreement. There's no special rules about it. For years and decades, they told us you had to have cause to non-renew a Section 8 lease or a voucher lease. That is not true. So there's no special rules. You can non-renew them just because you don't want to do business with them anymore. But you do have to get their permission before you can increase the rent or have a new extended lease. Other minor rules, but they need to know they're out there, is that money's going to come to you as a bulk payment for all of your Section 8 tenants. It's going to go directly into your bank account. Well, gosh, isn't that a partial payment? There's a specific rule on point under the statute 33-1371 that says it is not a partial payment because the tenant has no control over that money and they're not responsible for that money. The eviction pleadings, however, now have to list whether this is a subsidized tenant, and if so, how much is the tenant's portion and how much is the HAP provider's portion. As a reminder, everything has to go, a copy of that has to go to Section 8, including the eviction paperwork. So staying in the vein of fair housing concerns, which is what source of income is, handling an accommodation or modification request is still a very, very big deal. Remember, this is a big risk. If you do it wrong, you will get sued personally. You will be named in the fair housing case. So when it comes to animals or any kind of accommodation or modification request, remember, an accommodation involves a rule, a modification requires a tool, a physical change to a thing versus a change to a rule. It's important that you understand what you're allowed to ask. So if I want to add a ramp, you have the right to verify that I'm disabled before you grant that modification request, right? If it's a physical change to the property, it's a modification. If I have a readily apparent disability, I'm in a wheelchair, have a walker, have any kind of assistive device, you do not have the right to ask for any additional verification. If, however, whatever that disability is something that's not readily observable, you do have the right, and they have a requirement to produce that proof that they're disabled and that disability requires this particular thing. We're going to slow down for a second because some words are confusing. We are going to verify the disability of the tenant. We're not verifying that the animal has any kind of special training or that the animal has been deemed an assistive animal. If this is all really new to you, you need to take a good fair housing class that walks you through all of this. AAR has a class called How to Avoid Barking Up the Wrong Tree. And that particular class has 3 hours all talking about this particular subject. Under the ADA, so that's public areas like restaurants, maybe your business office, movie theaters, airports, all of those things. Service animals are permitted, not ESAs, emotional support animals, but they have to be a service animal, which means they have to be a canine or a miniature horse. Why? Because the ADA says so. Those are the only breeds or, species that qualify. And the owner of that business can ask, what has that animal been trained to do? But they can't ask for proof that the animal does that. If the animal's misbehaving, you can make that person who is in charge of that animal leave. Under our rules, under the Fair Housing Act, there are no species restrictions. There's no size restrictions, breed restrictions, species restrictions. You can ask what the disability is and verify that they are disabled, but you really can't ask for any special training of the animal. It doesn't matter if they're trained or not. If the animal is doing something, you have the right to evict the tenant or make them leave. There are times besides just dealing with animals that we have other fair housing issues. And these are the ones that I've been seeing throughout the pandemic, and they're still kind of lagging in this arena right now. Sometimes you waive late fees because you feel bad for that person, or they've never been late before, or the owner tells you to waive the late fees, or you have payment plans and you're not doing it equally for everyone. Be careful about that. If you are not careful, they can go in and look at your policies and find a pattern that you never even recognized was out there. So have a consistent policy about waiving late fees. You've never been late, I'll waive it once in a year. If you provide proof you've had a major medical issue, I will waive it or a portion of it. If I have a payment plan, what are your parameters? And if you're going to release them from the lease, what are the parameters where they qualify? And then what are you going to charge them for those lease breaks? The other issue that I've seen a lot in 2023 is an increase of litigation over security deposits. And we need to talk about that because it's a very important issue, because I am seeing the property managers named and the courts are not releasing you. It's a huge risk. So the beginning of this entire conversation has to be with, before you get sued, what did you do to protect yourself? What was the condition when they moved in? Because there's going to be a disagreement. The owner's going to say it's one condition. Maybe you weren't there. Maybe you didn't manage it. So having pictures or video of the move-in prior to their move-in, then they're going to return, hopefully, the move-in inspection form. If they send it to you, that is not a work order request, but you need to document it. If they've listed things, go out and look at those items and document them, because stains in the carpet, stains in the carpet, stains in the carpet. You're thinking, I don't remember there's stains in the carpet. Go right now, give a 2-day access notice, go look and see, show me the stains. This is probably someone who's never gotten a security deposit back. You want to be very careful about what they've listed. Go in and take a new video and make them point out exactly what they say is wrong, because that's how you verify what the condition was. And then if you haven't gotten it in a week, send them an email. Hi, Mary, this is Denise Holiday. I'm letting you know you moved in. It's been a week. I haven't got the move-in inspection form. I'm just reminding you that I need that back from you. We're going to be using my move-in inspection form taken before you moved in, because we didn't receive this back. So keep good documentation, because the owner says it was left like this, and the tenant says it was left in better condition than when I got it. And somewhere in the middle is likely the truth. So you, as the middle person, need to be very careful about what information you have to document these issues. And if you can have tools in your belt and policies in place, it will really help you and the owner and the tenant to avoid that. I have a client that I'm doing some litigation for, and they have a really interesting thing. When a tenant contests the security deposit, they immediately send them a letter that says, hi, Mary, I am so sorry that you feel like we've been unfair to you. Please fill this out. Tell me, what is it specifically that you disagree with? Or what do you agree with? And let me get to the bottom of that. Let me talk to the owner. Let me go back and review the evidence. When the tenant doesn't respond and doesn't send that back, that has helped us in litigation to say, look, we gave them the opportunity and they said, I'm not going to tell you. I'm just going to sue you. So think about creating that. Think about doing that move-out inspection together. I know you hate that. This statute, 33-13-21, says the tenant has the right to be present unless they threaten to kill you, right? And they were evicted for that. But you are required to tell them when you're going to have it. You don't have to schedule it with them and all agree at the same time, which I think is a good practice, but you are required to tell them when you'll be there to do the inspection, so that they can be there if they want to be there. That timing is important. Some of you require the keys before you'll do a move-out inspection. I understand that, because in your experience, you've gotten there and you've agreed to a 2 o'clock move-out and they're nowhere ready to be leaving and you're not going to wait around. Just make sure that there's a very short period of time from the keys to the actual inspection, because we're seeing people move in as squatters because they're following those trucks. Also, if the property's been damaged and they've turned in keys, they're going to say that owner's now liable and you don't even know if somebody broke in. So what can you charge? These are the things that I see frequently are mistakes. Even if you evict them, you can charge them rent until you get it re-rented or the lease is up, whichever is less. You can charge them utilities for that same period of time. The yard, the pool, whatever their obligations are under the lease, you can charge them. And you think, well, Denise, when they move out, I don't know when I'm going to get it re-rented. I only have 14 business days to send the deposit. Right. So right now you're going to accelerate the rent. If I moved out early this month and my lease isn't up till August, today I owe you for March, April, May, June, July, August. So you're going to accelerate that rent and put that on the move out, the security deposit disposition. You're also going to guess how many 6 months of utilities, 6 months of yard, 6 months of pool. You're going to accelerate that and estimate that and say, this is a preliminary. When we get the final number, I'll let you know. Cleaning, just because you can charge it doesn't mean you should. Look at the move-in inspection video. Look at the move-in inspection sheet. Was it clean? Did the tenant send you an email right away and say, hey, it's dirty, blah, blah, blah? Did you send someone back out to clean it? Were the vents cleaned when they moved in? If they weren't, are you charging them to clean the vents now? So be careful, because if you're wrong, there's a serious penalty. And the owner will probably throw you under the bus when they get sued too. Damages, remember, less normal wear and tear. So what does that mean? Well, when was the property painted in full last? When was the carpet brand new? You're not going to get brand new carpet when the carpet's 10 years old. Even if the dog ate it, you're not going to get brand new carpet. The judge is going to make you remove some kind of prorated life from that amount. I know this is really complicated. The point of this class is for you to go find out what this is, get a better education, find out where to get the information before you are in trouble. But these are the things we see that are creating litigation in 2023. And then remember that if the lease is not up yet, and you have charged that owner duplicate commissions because you wrote another 12-month lease, or you had cost for advertisement, you're allowed to charge that the tenant also. This is the law we're talking about, 331321, called the security deposit statute. You have to refund the money and send the itemization, refund it if they're entitled to any, and send the itemization. So be specific as clearly as you can within 14 business days. The statute actually says within 14 days, excluding weekends and holidays, from when you get the keys back or possession back. So maybe when the constable's doing the lockout, or you complete the abandonment process, or you get keys, however you get possession back, and written demand by the tenant. And there was a really big case that just came out from the Court of Appeals. When I read it, I was like, I can't believe anybody took the case that far. But the Court of Appeals said, look, when the tenant asks for what happened to my security deposit, they don't have to use any special words. They don't have to say, I'm hereby asking for an itemization of my security deposit. If they say, hey, I want my security deposit back, that's enough to trigger the statute. And you have 14 business days to get it to them. Here's my theory. I mail that form to the last known address, not certified mail, because certified mail is never forwarded. So I email it to the tenant. I mail it regular mail. I like to email it so that they know it's coming, and hopefully they've given a forwarding address. Sometimes they don't want you to have their forwarding address, but sending it there and then having proof when it goes to the postage machine, take a picture or make a photocopy of that and put that in the file. And then remember, you have 14 business days. You have 14 business days. So from my point of view, from the time I get the keys back, I start counting the 14 business days, because God forbid I got busy, I had a tragedy, I just forgot to stick it in the mail, whatever. If that happens, when the tenant says, hey, by the way, where's my security deposit? I now have 14 business days, because that's the final trigger. And that's, to me, your get out of jail free card. So you really want to think about actually understanding whether that's a good policy. I personally set my clocks a little bit fast so that I'm never late to any of my courts. And I think it's a good idea for you to just don't rely on that demand. Be reasonable. Understand what's normal wear and tear. There's going to be nicks in the wall. There's going to be pinholes for some pictures. Not holes where they mounted a TV, but minor stuff. That's part of just having a home. And then you have to be able to prove that you mitigated your damages. You took steps to lessen the amount of money that the owner was going to be out. So before you replace the carpet, try to have it clean. You have to replace the pad too. If so, keep a copy of that. What does that mean? Well, remember, if a picture is worth 1,000 words, smell is priceless. If you're replacing that carpet because of animal urine, keep a square. You only need about this much. Put it in a gallon-sized freezer bag, or a quart size, then inside a gallon-sized freeze bag. And you need the carpet that's saturated. You need the padding, the drywall. If you're going to charge, when you open that up, smell is priceless in that courtroom. So pictures and videos are great. Remember, it's hard to see sheens if they use the wrong sheen of the paint. Now you have to go through and paint the whole house because there's 400 little, dabs of paint where they use the wrong paint. But keep really good video and pictures of that. More than one format is always a better idea. And be reasonable. Most of all, be reasonable. If the tenant disagrees with that, respond quickly. Ask them for a better explanation about whatever that is. This particular slide is important because be precise. When you say, I am keeping $1,800 for, and you give a summary, but you don't do a breakdown, you're asking for someone to come in and sue you. You want to be able to be precise. I'm charging you $326 for this particular invoice. Or you attach the invoice and you say, I'm only charging you $200 of this invoice because the other things are owner responsibilities. Sending copies Sue Flukley, one of the things I think was a great suggestion years ago, she makes a private YouTube video when they move in and when they move out. And she always does, or before when she used to do property management herself, she did the same format. So you started in the living room, you walked this side. So when she moved out, she started in the living room and did that same path every time. So that when we're looking at it in court and there's side by side videos, following at the same pace, being filled at the same pace, you can clearly see the damages. And then make sure your owner knows what's happening. We frequently will get a lawsuit. The owner's like, I didn't even know you charged them for that $328. I don't care. I didn't want you to keep that. Be careful, because that owner is going to have a problem with you and likely will ask the court to keep you involved in that lawsuit, or they'll add you in as a third party. So make sure the owner understands what's happening. But remember this risk. If you have been found to wrongfully withhold that security deposit, the tenant just doesn't get that amount back. They get 3 times that amount as a penalty, plus attorney's fees and costs. So something that was really simple, like a $500 fee, is now $1,500 plus their attorney's fees and any of their court costs. Remember, they can sue you. The tenant can say that that you individually are the person that created that problem. They can say that they didn't actually do any of that issue. And additionally, they're going to ask for that 3 times. And the owner may name you. And the owner may say, hey, look, you're the one responsible. I don't even know anything about it. And then they can file a complaint against you. So be careful. Just because you can do it doesn't mean you should charge it. But what do you do if you have an owner that actually demands that you charge something you don't think you should? Please go talk to your broker. This is really dangerous. Document what you think is a problem. Don't decide on your own. If you're the broker, you can. But if you are not the broker, you should not be the one who says, I don't care. I don't think the tenant owes it. I'm giving back their money. But you also shouldn't be the one who's saying, owner, you're wrong. Tenant, you're wrong. And I'm going to give the money back, or give the money to the owner because the owner said so. This is a delicate balance. Slow down, document the issue, write down why you think it's wrong, talk to an attorney, talk to your broker, then communicate in writing to that owner. Here's what I think the concerns are. Please seek your own legal counsel. I have great concerns. I talked to our attorney. This is what our attorney said. If they demand, wash your hands, terminate the PMA. Hopefully you have that clause in your property management agreement, but say, look, if you're trying to do something that's against the law, I will not be part of that. I will now forward that deposit to the owner. I will tell the owner why I think it's not accurate. I will notify the tenant that the owner is reconciling those deposits and provide that tenant with the owner's address and contact information. Give the owner the tenant's contact information, but you need to step out of that issue or you will be named in that lawsuit. One of the final things I really want to talk about is casualty events. We've had quite a few storm damaged houses. We had a couple of fires this year. And you just need to know that there are some risks to you as a property manager. So this is the statute. You probably have never heard of it before because hopefully you've never had a casualty event, but it's 33-1366. What it says is if there's a casualty event that affects the habitability of the property, if it's completely uninhabitable, the lease ends, the tenant gets their prorated rent back and all their deposits, subject to if they owed you for something else. If a certain area is, but they can still live in it, then they're going to get a rent credit for the percentage of the square footage of the house that was impacted. This is complicated. Talk to an attorney. But let's slow down. Let's pretend they can't live there at all. And so the owner needs to be contacted. The insurance needs to be contacted. Sometimes everyone has to be out right away. At a fire case where they immediately had to go in, and because of the risk of the house caving in, everybody had to get out. That insurance company is going to come in and do their own investigation. The fire marshal is going to come in and do their own investigation. You need to be careful because you really shouldn't be walking in that because it's dangerous to you too. Try to do that as quickly as you can to get the tenant away from that area so that they don't have a safety risk. You are not required to put them in alternative housing. Red Cross will help, lots of other agencies, but you are not required under this statute. There's a casualty event to provide alternative housing. Right? The tenant gets to decide if they're going to leave and terminate the lease or leave and then come back when the property is repaired, stay somewhere else, and then just pay the rent when it's habitable again. They also, if it's going to be habitable, any part of it, they can stay and just pay reduced rent. It's going to be uncomfortable. They're going to have to deal with vendors. Lots of times tenants say, I want to do that, then they change their mind. Talk to an attorney. This is a very complicated issue, get you in a lot of trouble real easily. Remember, the landlord is not the insurer of the tenant's possessions, and neither are you as a property manager. But if there's some kind of issue that didn't get addressed, both of you may be named in a lawsuit. And here's what I typically see. Tenant sends a work order request and says, hey, the bathroom sink is leaking, or the toilet's leaking. You send out a request. The vendor says they try to get a hold of the tenant. They call 3 times. Tenant doesn't respond. You close the work order. Tenant falls, slips in the bathroom, breaks a hip. While they're in the hospital, you're there having your vendor fix it, and there's mold all behind the cabinets, and the tenant now has a mold claim. The owner's going to say, I don't live here. I hired you, and you knew there was a problem, and you didn't act reasonably. So you need something in your system that triggers what happens when a work order is opened. How do you follow up to make sure? Just remember that if the tenant is the one who actually caused the casualty event, you are not required to return their security deposit or prorated rent. Once you have that report that says they caused this, you can now use those monies. You can still terminate the lease, but you need to evict them under an immediate eviction. You use that money to now give to the owner, probably for their deductible, but talk to an attorney. This is very complicated. Remember, this market is complicated and our industry is complicated. If you did this back in 2006, 7, 8, 9, and 10, I think that's where we might be headed. And so be careful. You need some really good training, and you need to keep up to date all the time. That's why we offer this seminar. And that's why everyone who is a CRPM credential needs to take this, so that you know what are the hottest issues ever. So thank you for coming. And if you have any questions, feel free to reach out to me at my website or get a hold of anybody over at AAR, and have a terrific year.